Good morning, and welcome to the UVA Law Federalist Society's 6th Annual Originalism Symposium. My name is David Bainbridge, our chapter's symposium chair. I first want to let you know that this event is being recorded, and by attending, you consent to being filmed and to the use of your appearance in connection with this event. The Federalist Society for Law and Public Policy Studies is a group of conservatives and libertarians interested in the current state of the legal order. It is founded on the principles that the state exists to preserve freedom, that the separation of governmental powers is central to our Constitution, and that it is the province and duty of the judiciary to say what the law is, not what it should be. Before we begin with our first session, I want to thank the national staff of the Federalist Society for their constant support in making today happen, and the Arthur N. Roop Foundation for sponsoring our debate later today. I also want to thank Sidley Austin, Baker Botts, and DLA Piper, whose donations helped make today possible. Thank you also to our president, Ann Kreuscher, and the rest of the board, including Will Blevins and Kanishk Singh, for helping get this idea off of the ground. It wouldn't have happened without you. So now on to the first session. This year's symposium is titled Unwritten Law, Bridging Originalism and General Law, where we'll explore a hot topic in legal academia, the general law. What happens when the text of constitutional provisions runs out? While originalism emphasizes fixed constitutional meaning, the founders may have presupposed a broader legal framework beyond written law. Some call that framework general law. This year's symposium explores the intersection of the general law with originalism. Should originalism incorporate general law to recover the Constitution's original meaning? How does it inform modern doctrines like the Second, Fourth, and 14th Amendments? And what are its implications for debates on natural rights and constitutional structure? Our symposium hopefully addresses some of those questions and more. To kick us off, we have someone over Zoom who needs no introduction in this space. Professor Will Baude is the Harry Calvin Jr. Professor of Law and the Faculty Director of the Constitutional Law Institute at the University of Chicago School of Law. Professor Baude has written extensively on the contours of the general law and its impact on the Constitution, particularly in the Second and 14th Amendments. Professor Baude received his undergraduate degree in mathematics from the University of Chicago and his JD from Yale Law School. He then clerked for Judge Michael McConnell on the U.S. Court of Appeals for the 10th Circuit and Chief Justice John Roberts of the United States Supreme Court. Professor Baude also co-hosts the popular legal podcast and now blog Divided Argument with Professor Dan Epps. Please join me in welcoming Professor Baude.
Thank you for the introduction. Thank you all for coming. I am extremely excited about this conference, and my biggest regret is that I'm not there in person to participate, but I am excited to kick things off. I'll tell you a little bit about why I'm extremely excited and why this is one of the most important topics for people thinking about constitutional law generally and originalism specifically to be addressing. So I guess I'm going to go through a little bit of a why, and then a little bit of a what, and then a little bit of a how, and then talk about what I'm hoping to hear for the rest of the sessions. Originalism, as everybody attending this probably does not need to be told, is a reorientation, I would say a recovery, in our ways of thinking about the Constitution and constitutional law. And it's fundamentally also a truth-seeking approach to constitutional law. Right? Originalism provides an answer to the question, what are the truth makers for claims about constitutional law in our system? In virtue of what would we know whether the Constitution does or doesn't permit states to regulate abortion, does or doesn't permit the president to take various executive actions, does or doesn't permit Congress to enact various laws, and so on? Originalism provides an account in which the answers to all those questions come from the Constitution and the understandings or the law surrounding the Constitution when it was enacted, as well as amendments and other lawful changes. It provides sort of a fundamental structure for thinking about our constitutional system. And I'll confess, when I was a law student, first trying to think through the basic answers to these kinds of questions, that's part of what led me to originalism. Was it seemed like a theory that actually had answers to those questions, or at least had plans to provide answers to those questions, or at least plans to tell you in virtue of what you might find answers to those questions. And without meaning to denigrate the many lovely non-originalist theories of constitutional law out there, originalism was one of the few theories of constitutional law that seem to actually be attempting to provide answers to the those questions about the truth makers in our constitutional system in a consistent and coherent way. And I think that's been one of its great strengths and one of the ways in which originalism can continue to work itself pure and try to figure out how does precedent work in our system, what is the nature of the separation of powers, and so on. That's part of what's been so great about the Originalism Symposia at the University of Virginia, which I've benefited from a lot over the years. But a funny thing happens as you start to really push on the Constitution and on its text and original history to figure out the basic questions about the structure of our law, about our rights and liberties, about the powers of government, about the relative powers of different governments and different branches of government. So let me tell you about that. First, the gap. There are things that you would expect to be answered in setting up the constitutional government that the text of the Constitution and the relevant original history doesn't obviously answer. And those start to seem puzzling. For instance, what are the procedures in our courts, in federal courts, for litigating constitutional claims? I mean, that may seem like a relatively minor issue. Surely courts can set their own procedures as part of the judicial power. But some of these procedures sort of cut to the heart of who wins and who loses and what constitutional rules will be enforced. For instance, principles of stare decisis and precedent. When and why and in virtue of what can courts decide not to apply the Constitution itself, but instead to apply things courts have said about the Constitution, even if those things might be wrong? Now, I know we had a symposium on originalism stare decisis not that long ago, and so you know that some of the answers, some people would say, never can courts apply anything other than the true Constitution itself. Never can they apply the precedents established by themselves or other courts. But that's never been by our tribunals throughout our constitutional history, which is puzzling. And yet, if there's no answer to that question, or if constitutional law or all of law is silent on that question, what gives? Does that mean that the Constitution itself can just be papered over or shingled over by a series of precedents constructed by the courts with no limits? Or to take something that's been the subject of recent literature, what about the rules of waiver and party presentation? It happens every day in the litigation system that the courts don't apply the truth about the law with a capital T, but instead they provide an answer to the question that the litigants have asked the court to answer. They confront the claims raised by the plaintiffs and the objections made by the defendants, rather than thinking through in first principles in a sort of German inquisitorial fashion what they would think about the Constitution if they were the ones asking the questions and giving the answers. That's a basic feature of our litigation system, which again can be uncomfortable in particular cases because it can mean that the true meaning of the Constitution sometimes sits outside of what the court has decided to answer. So where does that come from? Where are the rules about when courts can do that? Or are there no rules? Or do the rules just come from the courts themselves? Is it never allowed? There are lots of puzzles there. Another set of gaps that everybody here will have confronted. The Constitution knows what it's talking about. For instance, the Constitution talks about legislative power, the executive power, the judicial power, without clearly giving you a definition about what those things are, what kind of power those are. And we know that the framers of the Constitution and the ratifiers of the Constitution and those who lived under the Constitution had experience with legislative power and executive power and judicial power. Of course, those powers existed and were debated in England. They existed and were debated under state governments. But the Constitution just sort of refers to them as if we knew what it was talking about. So do we? Where does that come from? I'll tell you, if you look just at a dictionary from the founding era period, it won't just give you a full list of what those powers mean. So where do those legal terms come from? And it's not just the legislative, executive, and judicial powers. The Constitution is shot through with other terms that seem to reference some bodies of law that we're expected to know something about. The privilege of the writ of habeas corpus, the freedom of speech, the right to keep and bear arms, due process of law, liberties throughout the Constitution that are not spelled out in specificity, and yet at some point we're going to need specific answers about their content. So what are those? Where would we find the answers? What body of law talks about those? It's another gap that starts to emerge as you look at the Constitution. And then, of course, there are even bigger gaps, not just interstices or ambiguities or lack of specificity, whole topics you would expect the Constitution to say something about that it doesn't say much about. Relations between the United States and other sovereigns. Does the Constitution have anything to say about that? Lawyers have confronted this question of relations among the states. You know, it comes up now that we have a debate between Texas and New York about who can regulate what parts of the practice of medicine that might affect Texas or might affect New York, and there are debates about how to think about that. That is the kind of thing you would expect a constitution uniting states into a nation to say something about. The Constitution has a full faith and credit clause. Maybe that's relevant, although the originalists have looked most closely at the clause, have concluded that it doesn't tell you whether New York regulate the practice of medicine in Texas, or whether Texas can regulate the practice of medicine in New York, or if they can't, what the limits of that rule are, how to understand them. In fact, there's a whole field of law that these days is basically a downstream consequence of the fact that nothing in the Constitution seems to tell us how the states relate to one another or what to do when they want to do different things with the same transaction. That's a big gap in a Constitution that's supposed to create a federal system by uniting states into one, by making one nation out of many states. So why is that a gap? What kind of law is that? What's going on? Second, as you look into not the text of the Constitution, but the history of the Constitution, you discover a presence, right? So as you start looking for answers to these questions, what bodies of law did they look to answer these kinds of questions, these gaps in the text of the Constitution? You discover that they had a body of law that we don't have anymore, that looks kind of strange. They might have just called it the common law. These days, we tend to call it the general law to emphasize that it's not just the common law of one particular state or jurisdiction, but a shared law. I'll get back to that in a minute. But they seem to have a lot of law that we don't have anymore. They had the law merchant. Do we have that? Is that just the commercial code? Is that just contracts class? Not quite. But they treated it as a unwritten body of law with comprehensible principles that they could talk about, derive, write treatises about, and so on. They had the law of nations, international law. We debate whether we have international law too. My colleagues here at the University of Chicago tell me that we don't have it anymore, but they had many books about the principles of international law and what they were, and they weren't just set down in treaties or a pre-UN charter. They seem to be derived from custom and practice and the nature of things. They had conflict of laws. Right? They had answers to those questions I was asking earlier about in virtue of what can Texas regulate New York or New York regulate Texas, or how do we decide what to do when two states have regulations on the same topic or just common law on the same topic that aren't the same. They had a whole series of answers about those questions that they called the general law, and a body of law called conflict of laws. And more. They seem to have law, unwritten law, on just about everything that we might think about. They did not live in a world of statutes where they had municipal codes on all topics. They were creating those things where they thought they needed them, where they thought the unwritten law failed or needed clarification or needed to be changed. But they lived in a world just shot through with unwritten law that wasn't just the law of any particular jurisdiction. So what do we make of that? And in my view, the topic of today's symposium and the sort of general topic of inquiry, originalism and the general law, is an attempt to figure out how those things fit together. Right? How does the original meaning of the Constitution, with its strange gaps on topics we might expect to be addressed by law, sit together with the large bodies of unwritten law that they thought addressed those questions? Now I have my own views about how to fit those things together, and I'm talking about them in a minute, and I'm sure many participants in our symposium will give their own views about those questions. But that's, I think, the central puzzle that just emerges as you try to look at the world, try to look at especially the world at the founding, and their legal system, and then try to think about what to make of it today. All right, that's the why we're asking this question. Now let me talk a little bit about the what. What is the general law? And its cross-jurisdictional character. Those were the things that made it general. So first, on its unwritten character. The general law was conventionally unwritten law derived from general principles and customs. Chief Justice Marshall once called it those general principles and those general usages which are to be found not in the legislative acts of any particular state, but in that generally recognized and long-established law which forms the substratum of the laws of every state. General law included, as I've alluded to, particular bodies of law like the law of nations, as well as the law merchant, the law of admiralty, but it also included, principles that stretched across nearly every common law topic. Indeed, it wouldn't be an exaggeration to say the general law was just common law. An important feature of common law at the time, though, was that it looked different than how we think about the common law, or at least how many lawyers, perhaps most of the people in this room are an honorable exception. It looked different than how we sometimes think about and teach the common law today. Nowadays, the common law is sometimes thought of as just judge-made law, the body of law produced by the courts of some particular jurisdiction. So the common law of Illinois is the stuff the Illinois Supreme Court says it is, and the stuff the Illinois appellate courts say it is if the Illinois Supreme Court hasn't said what it is yet, and so on. That is not what the unwritten law or common law looked like at the founding, so it's not what general law looked like. At the time, judges were not understood to have that same ability to just create and be in charge of a body of law. Courts were not administrative agencies in charge of promulgating the general law. Maybe administrative agencies aren't like that either anymore after Loper-Bright's healthy reorientation of administrative power, but that's another symposium. So we're talking about unwritten law that's not just judge-made law, but rather derived and found rather than made. I'll talk a little bit more in a minute about how it was found rather than made, but that's the basic idea. Unwritten law, common law. But general law, general, the reason we need a label for general law besides just common law, was that it was also not just the unwritten law of any particular jurisdiction. Unwritten laws could have their own jurisdiction, jurisdictions could have their own unwritten law, right? The courts of Massachusetts, or the people of Massachusetts, might well have customs and principles on some particular point that differed from the customs and principles of the people of New York or the people of Texas, or the people of Virginia. But there were also principles that were not localized to any particular jurisdiction. They were just the general principles thought to, as Chief Justice Marshall said, be the substratum upon which all the other principles and localities were built. That's what made it general, shared. Again, you could use the label common law for this, and often at the founding they did, because common law, after all, was supposed to be common. But as we've lost our own grip on some of these concepts, we need our own labels to hook back on what they're talking about. General law is what people in federal courts and civil procedure and scholars have generally labeled it. General law meant that it was changed, meant that it was shared. The cross-jurisdictional character of general law meant that no single jurisdiction could control its content. And notably, courts acknowledged this interpretive independence, even when a state had sort of incorporated a general law rule into its local law by reference. To quote your own Caleb Nelson, a state's decision to adopt the general law did not necessarily localize the general law. States instead would sort of embrace general law on a topic and acknowledge they were part of a shared project, one where their courts did not have the authority to settle its content, just as other courts did not have the authority to settle its content. Instead, they were each called upon to perform the same functions in expounding or explaining what the general law was. That was the way the general law principles could be shared among different courts, and courts would try to, over time, settle on how those principles worked. As you can imagine, the law of nations used to work this way. The point of the law of nations is for the nations to share a law. So any individual nation didn't purport to speak for the law of nations for everybody. Now, nations might sometimes violate or deviate from the law of nations, and they might sometimes localize or adopt principles of the law of nations to their own particular needs and circumstances. But the idea, anyway, was that everybody was engaged in a shared legal project to describe, articulate, expound general principles of law that worked in the absence of any localizing or statutory force. So, general law, unwritten law that had a cross-jurisdictional character, just shared across different jurisdictions, different adjudicators, and found rather than made. Okay, that's the why and the what. Now I'll talk a little bit about how. So how did we go about expounding, finding, articulating this general law? It's tricky, and even trickier in some ways for us lawyers today in the 21st century, uh, long after these ideas have sort of mostly fallen away from practice and perhaps even been declared illegal and unconstitutional by our Supreme Court. But let's start back at the beginning. The basic idea of the general law was that it was found through both custom and reason. And in a way, those were sort of the two pillars, the two threads for how to think about unwritten law. Custom, the custom thread, we might think about as just practice in the sort of base sense. What is the majority rule? What do most courts think the law is? Or even not just courts. What do most people, what do most merchants, what do most officials of various sovereigns treat the law as? What is the custom? How do we do it around here? Reason was more about principle. It's more about, well, what is the right way to think about these things in light of the basic principles of this area of law, right? In light of tort's goal to provide vindication of various individual duties of law, in light of contract's goal to realize the legality of certain agreements, and so on. And those two things might well be different, right? You might have a custom in an area of law that seemed to be inconsistent with first principles when you really thought about it. Those were the hard cases in general law, the tension between custom and reason, but those were the two threads. Most cases, they would align. Right? In most cases, you could say, the custom is X, and the reason the custom is X, because it also follows from these reasons Y. Everybody would know that was the general law, the general principle of this area of law. And in the harder cases, you'd have to think about the ways in which the custom and the reason were in tension. There are lots of ways to think about these threads. Sometimes modern jurisprudence scholars think of the custom thread as what they'd call positivism. It's just descriptive of what we do. And people think of the reason thread as more like natural law, right? It's not what we should do, but it's in the nature of things as a matter of some kind of first principles, the way we should do it. I think those labels are probably deceptive or anachronistic. I think both custom and reason were threads of the way of thinking about the law and threads of how they thought we should think about the law at the time. But in terms of our sort of current habits of mind, you could think of them working together that way. And candidly, one of the big unworked out questions, I think, among modern scholars is how to think about the relationship between custom and reason in finding and articulating the general law. This is probably, candidly, something that they disagreed about, and that was one of the kind of constant tensions in general law in the 19th century. There were jurists who seemed to lean more heavily on reason, more willing to defy or revise the general practice when they thought that the true first principles of this area of law pushed in another direction. There were judges who seemed to lean more heavily on custom and be disinclined to hear any call that the practice had misunderstood the reasons of the area of law, because that's just the way we do things around here. And balancing those things across different judges with different ways of thinking about things and in different circumstances was one of the great projects of the 19th century common law, the classical common law. And I think we don't yet have a great handle on how to resolve those things, how we today ought to think about those dilemmas. We know the two strands, but we don't know exactly how to weave them together, or what the pattern will look like. And that's a topic that, I hope the next generation of theorists and historians will be able to sort their ways through. How do we work out the dialogue between custom and reason and unwritten law? Then matters get even more complicated, because what happens over time? If there was general law on a topic at founding, say, or at Reconstruction, is that still the general law today, or could it be different? And this depends in part on the relationship between custom and reason. Customs change. So to the extent that the general law rule derives from the practice of courts, the practice of people, and to the extent that the practices have changed sufficiently over time, the custom thread may well look different. Reason, depending on how you think about the world, depending on how you think about truth, might be much less likely to change. It might be much easier for somebody leaning on the reason pillar to say, yes, sure, we do things a little differently around here, but that's a problem, right? We've gotten away from the true first principles of this area of law. We've gotten away from reason. So one of the next questions in thinking about originalism in the general law will be thinking about how much can the general law principles validly change? To what extent does a change in practice mean a change in the established legal rule, and to what extent does a change mean, well, something wrong with our practice? And I hope that it's encouraging. I'll just say, this was not a problem. This is not a new problem. This is a problem that even existed at the founding. In one of my favorite common law cases, quoted in the literature by some of the members here, Livingston versus Jefferson, Chief Justice Marshall, sitting as a lower court judge, confronts this problem and thinking about the distinction between transitory and local actions in a trespass case involving his political foe, Thomas Jefferson, saint of the University of Virginia, and says, there's a rule here that wouldn't allow him to hold Jefferson liable, even though he would very much like to hold Jefferson liable. And the rule, frankly, doesn't make a lot of sense and seems to have emerged in a way that he wouldn't have signed on to if he'd been in England when they were deciding these cases. And he thinks it's kind of a deviation from the true first principles of their law, but it's the rule. It's been established by sufficiently settled practice. He says, I don't really feel at liberty to change it anymore. And so sticks with the customary rule, despite his misgivings about the way it's evolved. That's just one example. Of course, there were dozens and hundreds of examples, and we confront new dozens and hundreds today. That's another one of the hard questions about the general law. But I think it's the kind of question that originalists, equipped to think about legal change and what parts of the law of the past bind us today, and what parts of the law of the past are left to future circumstances to change. It's the kind of project that originalists are better equipped to have an answer to than any other legal scholars, and frankly, need to have an answer to, because the gaps in the original meaning of the Constitution itself and the brooding omnipresence of the general law, mean it's natural that our questions about constitutional change will spill over into questions about general law and common law change next. All right. That's how I see the general relationship between originals and the general law. That's why I think it's important that we're having this symposium and sort of ask these questions. There are a lot more questions to ask that I'm not going to address in this talk that I'm hoping that our symposium and our panelists will address. Obviously, the basic questions of, well, how does general law sit into our Constitution? What things are instead controlled by the text of the Constitution, or instead given by our Constitution to particular institutions to decide for themselves, and what things are left, to still be regulated by the general law? I've done work with several co-authors who are here on the original understanding of the right to keep and bear arms, on the Religious Immunities Clause, suggesting those clauses draw on general law. Other panelists have different claims about when, whether, why the general law speaks to these various topics. But how do these two things fit together is going to be a huge progress in trying to answer those kinds of questions. Before turning things over to start the next conversation, or perhaps hear questions from you, I have three other thoughts about the relationship between originalism and general law that I want to put on the table for the conversation today. First is about Erie Railroad versus Tompkins. Right. Another way of thinking about the topic of the symposium is, what does civil procedure have to do with constitutional law? Or what does Erie Railroad versus Tompkins have to say to constitutional law professors? In Erie, in capsule form, the Supreme Court said there was no general federal common law, stitching together different adjectives, general, federal, in a sort of strange way, but sort of tried to deny the existence or the legality of this category of law we've talked about, vindicating Justice Holmes and the other proto-realists who thought there couldn't be law that didn't ultimately come from the command of a particular sovereign. So unwritten law just had to be judge-made law, or somebody-made law, and cross-jurisdictional law didn't really make sense because it had to come from some jurisdiction. If it was cross-jurisdictional, it was federal. It couldn't be general and non-federal and shared. Erie Railroad is wrong. It's certainly not originalist. It's certainly not the way people thought about law at and after the founding. And it casts a long shadow on our ability to think about the law. And so a big part of the project is just going to be setting aside our Erie blinders. Maybe we have to accept Erie as a matter of stare decisis. Maybe Erie has become true over time in some roundabout fashion, but we have to think past Erie a little bit. And I think it's important to acknowledge that Erie proceeds from some very healthy instincts that a lot of originalists probably have, right? Erie proceeds from both a separation of powers premise and a federalism premise. You think of Erie as saying, federal courts shouldn't be making law for the states. They should be sitting back or receiving law from the states. Thus, at least federal courts should find law rather than make it by letting states, do whatever it is they do. It restrains federal courts, at least, from judicial activism, something that originalists and Federalist Society types have long been in favor of. And federalism, in that Erie is against the federal government being the one to impose some sort of common law on the states, instead saying, no, the states can each have their own common law. So the federal courts will, there will be neither federal judge-made law nor federal judge-made law for the states. Right, in general, we don't have enough adherence to the separation of powers and judicial restraint. In general, we don't have enough federalism for the true original meaning of the Constitution. So it's a little dangerous to suggest that Erie was wrong. We might get rid of those things. But Erie imposed a kind of separation of powers and a kind of federalism that were not the kinds that our Constitution imposed. And so in thinking about the actual original structure of the Constitution, we have to think about the things that Erie got rid of. But that also means thinking about how to still make sure that separation of powers and federalism are part of our system in a world without Erie. That may require attention to even more parts of our system, but it's worth thinking about those principles, lest we take apart the few useful principles of restraint we've developed over the 20th century. Another thought is about the nature of originalism. Sometimes conversations about the general law and originalism seem like they're going to reduce to conversations about different kinds of originalism. You might hear somebody say, I don't believe in the general law, or I don't need to think about the general law because I am an original public meaning originalist. And to me, originalism is just a theory of the Constitution itself and the fixation of its text and the way in which its fixed text constrains us. General law is for original law originalists who believe that originalism is not just about the public meaning of the text, but also about all of the law that existed at the founding as it's been lawfully changed since. I think this is an overstated distinction, and I don't think that the kind of originalism you believe in affects whether or not you need to be part of the general law project. It might on the margins affect some of the answers to these questions about when the general law is part of originalism and how it changes, but I don't think it affects the whether question about whether to have an account of general law and how it changes and how it fits into the original meaning of the Constitution. After all, the meaning of individual terms in the Constitution reference general law or seem to have been understood by their speakers and listeners to incorporate general law in various places, as we discussed and as other panelists will talk about. Or, of course, all sophisticated originalists recognize the need for context and pragmatic enrichment and various implications. And general law was a central part of the legal context for so much of the law at the founding that even originalists who think of themselves as focused on the public meaning of the text shouldn't be blinding themselves or sort of abstaining from questions and conversations about the general law and how it exists, whether it exists, and how it changes. It's got to be true no matter what kind of originalism you think of. And so this shouldn't be a sort of sectarian debate about the different kinds of originalists. This is just a fact that arises from the gaps in the Constitution and from the brooding omnipresences that existed at the founding. Whether that brooding omnipresence indeed fills those gaps and how to think about the fit in the brooding omnipresence and the gaps, that's a question all originalists should be thinking about, whatever their answers. And that leads me to the sort of last point. In writing and speaking about general law and originalism, I think I would advance at least both a strong claim and a weak claim. And the strong claim is something like, we have to fundamentally reorient our way of thinking about the law in light of how central unwritten law and general law were to the legal system that our Constitution actually created. The entire 20th century and 21st century common law curriculum, in a way, misunderstands the nature of the general law. Our entire structure of adjudication, in which courts are understood to make law, in which we have a very judicial supremacist system, in which the Supreme Court sits atop all the courts and articulates answers that immediately bind everybody else. All of that is contrary to basic principles of the general law. So recovering sort of true general law originalism might require the elimination of judicial supremacy, the restoration of a classical view of the common law, a new view of precedent, and much more. I think that's probably true, and part of it makes the project large and one that'll take a generation to realize in strong form. But I don't think you have to accept the strong claim to be part of this conversation or even to recognize the importance of it. The weaker claim which I hope will be irresistible, is that at a minimum, originalists have to have an account of how the general law relates to the Constitution. Maybe the account is the general law was killed by Erie Railroad versus Tompkins and subsequent developments, and that death is perfectly lawful under the original meaning of the Constitution. So there is no more general law anymore, and things are just weird now. Or maybe that account is the general law is an important piece of legal context to be used when construing the textual provisions of the Constitution and affects different clauses differently in ways that scholars will work out across different provisions. Maybe that account is the correct, stronger account I just described. But at a minimum, all originalists have to have an account of how the general law relates to the original meaning of the Constitution. Without it, our picture of the Constitution just has too many unaccountable gaps, and our reaction to one of the biggest facts, the biggest brooding omnipresences about founding era law, just lacks any answer to the elephant general law in the room. I hope this symposium is going to give us all a better chance to work out what those accounts are and what work we still need to do in the future. Thank you all for listening.
Thank you, Professor Baude. I think we have a little bit of time for some questions, if any of you have some.
Good morning, Professor Baude. Thanks for doing the talk today. Something that I've heard in some general law talks before is trying to square the temporal aspect of custom in terms of looking at customary meaning at the time of the founding versus now. I think a good example is cruel and unusual punishments, where maybe in the late 1700s, if you were a pickpocket, there was some customs of people getting hung. And so today, under this theory, could someone, could a state say, we're going to go back to this customary practice of hanging pickpockets and thieves if someone misses an item at the checkout at Costco, that we can do that? I'm just trying to square that. I think all of us know that doesn't make sense, but under general law and the principles you're proposing, like why wouldn't that work, or could that happen?
So we shouldn't be so sure that couldn't happen. I'll just start by putting that on the table. I realize Justice Scalia famously said, the idea that you could have flogging as a punishment, even though it was present at the original at the founding, was just so obviously untenable that he wouldn't allow it, even though maybe the originalism required it. And he described himself as a faint-hearted originalist for those reasons. I think in the last years of his career, he then said, maybe he wasn't faint-hearted anymore, and he worked up the heart to say, maybe you could do that. And of course, it's also true that the very fact that it strikes us all as such a crazy outcome, I hope, is one of the reasons it hasn't happened. It's not just that people think that the original meaning of the Constitution forbids it, but it's contrary to our norms and contrary to, therefore, what anybody would do. So the answer to it depends on two things. It depends on how much the common law of punishments, let's say, was customary versus normative or reason-based. And it depends on the original meaning of the cruel and unusual punishments clause and how that sits atop those two things. And I think both of those things probably provide some reason to doubt that it would just be a matter of changing customs. I think as the common law of punishments, probably the first principles, the reason strand, was understood to do a lot of work. And so it's not necessarily the case that a change in custom would change the answer to what was a proper punishment. More importantly, I tend to think, like just about everybody else, that John Stiniford is probably right about the original meaning of the cruel and unusual punishments clause, which is that it had both a unchanging and changing character, and that essentially what it forbade was, new punishments that were also cruel, or new punishments that were contrary to long usage that also seemed cruel. And I think a lot of the torture of shoplifters or might well flunk that test, even if at the founding it wasn't new.
Thank you, Professor Baude. I'm curious, you're talking about potentially overturning Erie or replacing it with some kind of system. Could you outline a little bit what you think a successful replacement system might look like?
I'm getting ahead of ourselves. So the system we had for a long time was something more like the Swift versus Tyson system, which said there are general principles of law that both federal courts and state courts are equally competent to address and discuss. And those principles presumptively control at both federal and state courts. Now, Swift still conceded that states could, if they wished, deviate from the general law and establish local law on particular topics that were previously part of the general law. So it was a sort of intermediate solution. You could imagine doing that through clear statement rules, through all kinds of things, and saying, in general, we will have a sort of default that federal courts and state courts are on even footing trying to work out the law for themselves, and have a sort of clear statement rule for states to deviate from it. My predecessor in office at the University of Chicago, William Winslow Crosky, a constitutional law professor, thought that that compromise was wrong, and that the federal government ought to have more power and the states ought to have less power to deviate from the general law than what I just described. I don't agree with that, but that would be another option on the table, and it would look like a system of much more federal control of all these things. That'd be one possible wrinkle. Another wrinkle would be we would then have to think more about when states are allowed to deviate from the general law. That would put more pressure on some of the conflict of laws questions we've talked about if it's a cross-jurisdictional commercial transaction, can a state just say, well, we don't obey the general law here, and when does that prejudice the vested rights of people from other states in a way that states have to respect, and so on. And those are the kinds of questions that the Swift regime then had to wrestle with. But I think at a first cut, it might look a lot like the regime of Swift versus Tyson, or at least that regime until it sort of devolved and frayed over time. One, actually, I think, kind of helpful way of thinking about it is the way the American Law Institute thinks about restatements. So the American Law Institute, and indeed before Erie Railroad, a big part of it, what they saw their job as doing was to help everybody figure out what the general law was, right? To take areas of law that were dealt with by lots of different states and say, in general terms, what the principles of that area of law were. So you might think of it as the project of writing a restatement, or especially like the first restatements. And the American Law Institute squarely confronted the sort of custom and reason problem. They said, in general, the reporters in the restatements should lay out, just descriptively, what do people do, what is the rule, but then sometimes they can make the case that the majority rule is not the correct rule, if you think about it from first principles, from reason, and they should explain why that is and why. It was done, again, in a very academic fashion, because we are academics. But you could think about the restatements, especially as they were originally conceived, as a big way of trying to think about and articulate what the general law was. And so maybe that regime would just look a little bit more like the American Law Institute.
Hi there. I was just really curious how you can marry the ideals of judicial restraint with the general law. I just have a concern with policy distinctions or policy motivating decisions, but being glazed under general law.
Yes. So this is a big problem. Although I don't think it's ultimately a problem caused by the general law. And in a way, the general law itself, this is part of what the battle between custom and reason was about, I think, is those jurists who thought the general law should be much more about custom than reason, were thinking about that from a point of view of judicial restraint. The judges should just do what all the other judges do, and not get too creative or fancy in trying to critique or figure out what the first principles of the area of law are, precisely because the first principles of the area of law will be the same as whatever it is you as a judge. Load-bearing strand of the general law. I'm not sure it's a reason not to do the general law at all. It's probably no secret to anybody studying law today that the presence of legal texts has not stopped legal activism. The judges also have the ability to interpret and construe written texts in ways that bring in their own predilections and policy preferences if they want to. And so I think both the general law and the written law have the feature that there is an objective thing to look for there if you don't want to be a judicial activist, but nothing about the general law or the written law like reaches off the page and grabs your throat if you want to be a digital activist and are trying to stop. And so I'd say, in a way, what the general law reminds us is that judicial restraint partly has to come from within. It partly has to call for judges who actually want to be judges and find the law and not make it. And if the judges want to do that, then the law needs to provide enough resources for them to be able to do that, to have truth to be able to apply. If judges don't want to do that, there's not a lot the law can do to stop them, written law or unwritten law.
If there are any.
Thank you, Professor Baude. My question, I guess, is a potential tension between the general law and originalism as fixing the meaning of the Constitution. Because it seems like, from how you've described it, the general law implicitly understands some level of change over time. Presumably, the general law of 1776 was not the same as the general law of 1676. But originalism makes the claim that the general law at the time of the Constitution or the time of amendments being ratified should essentially calcify to how we understand the general law. So I was curious if you could speak to that tension and how we should think of that as originalist.
Good. So I'm not sure it's right. So this is I think this is one of the things that makes the general law a tricky project. So originalists don't have to think the general law is the calcified general law. It might well be, I tend to think it is the right way. The originalists should think the general law is the general law of 1789 plus any lawful permissible changes in the general law over time. So the extent that the general law changes for reasons that the general law permits, that's okay. In the same way that an originalist thinks that the statutes of Virginia are the statutes of Virginia that were in place in 1789, plus all of the lawful changes to the statutes of Virginia over time, duly enacted by the Virginia legislature and consistent with the U.S. Constitution. So you could think of this not as constitutional law that has to be hard-coded, so much as an important body of law that the Constitution assumes protects from certain kinds of change, but allows to change in its own internal way. Or the number of states, right? There were only 13 states in the Union at the time of the Constitution, and not all of them signed the Constitution right away. That number can change over time. Originalism doesn't say no new states. Originalism says, here's the procedure for recognizing new states or the terms on which they enter. And so it might be that the general law works the same way. Now, there are some people who are originalists, I think, because they are skeptical of all change. And for them, thinking about the general law might, be destabilizing or something to disfavor. That is what the people who favor the reason pillar of the general law tended to think. Is they tended to think it didn't make sense to think even that a bunch of incorrect judicial decisions could change this fundamental area of law. So they tended to emphasize reason over custom, in part to keep the general law more fixed and stop it from changing. But then that gives rise to the worry about judicial activism that the previous questioner asked about, and that's why the battle between custom and reason was never won decisively by either side.
We now have a break, and the next session, General Law and Historical Perspective, will start at 10.